intended nor the scheme intended. And, my lord, kindly bear that fact in mind. On 11th of March, my lord, we thought that we are ad item, that this information would help the voter to take a call whether to vote in favor of a particular party or not. My lord, thereafter, this started in a very systemic.
Already. Order.
Can I assist you?
No, Mr. Rodgi, we don't need assistance right now at the conclusion.
I am the person who's going to.
Lord, they have no stakes in the matter.
Forget my application.
No, Mr. Rodgi, we'll not hear you when your application. We have to follow procedure in the court. It's a constitutional court. Yes, Mr. Rodgi, no, Mr. Rodgi. I told you the reason for it. We are now at a stage when the judgment.
I am not on my application. Not that it has become influential. I am now only saying.
No, Mr. Rodgi, we don't need any assistance at all. We are clear. We had very able assistance on both sides. We don't need any third party assistance.
You didn't get a proper assistance.
So just one thing. Grievance of those who will now be deemed that you have A party, you have given to B party. That will be
your side to ask. That was
Lord, one more clarification.
What we did that he gave to the government under a scheme.
Mr. Rodgi, there's only one simple answer.
Yes.
With effect from the 12th of April 2019, when we directed the collection of all details, everybody was put on notice that hereafter, the details which you furnished would be subject to the result of the petition. Therefore, in drawing the balance, we did not ask for the disclosure of details prior to the interim order of the court. And that was a very conscious and well thought out decision of the Constitution bench.
Was it the intention of the court to know which man paid where, so that if he pays A party, he will be subject to victimization?
Answer is yes.
The answer is yes.
Lord, only one line, my lord. Only one line, my lord. Mr. Bhushan may, my lord, now hold his horse.
Pursuant to your.
He has done, my lord, substantial assistance. I don't have to formally disassociate myself with today's mentioning, my lord. That my disassociating from Mr. Agarwal doesn't mean that I am.
Mr. Solicitor, irrespective of
but maybe treated as well.
We must just tell you that we respect this very responsible approach which the Solicitor General has adopted of, because, clients apart, who you are representing apart. The
it is really painful, my lord, when the people before the court start, my lord, a media campaign to embarrass the judges.
Thank you for saying that you don't associate with the mentioning. Thank you for saying that you don't associate.
Because there is no level playing field. I can't hold a press conference.
Only grievance is that it was not a justiciable issue. Yeah, Solicitor General did not raise it. It is not a matter of pure policy. I read the entire judgment. It was entirely a policy issue. It is not justiciable at all. That's all I want to say. The people of this country feel that a decision was taken behind their back. When the parliament decides, they were present in the parliament. It is with their consent. When your lordship decides, we are.
Last order, the Election Commission has put out the sealed covers, but that's very interesting that those sealed covers show that some of the smaller parties have disclosed the donors.
We don't have to go into all that. That's not our remit at all. What has happened after the judgment is not something we are concerned with.
Not after the judgment. What I'm saying. What I'm saying is this: that since the order of the.
Very recently, I was asked about a critique on a judgment. I need not mention which judgment, and I said that look, it's no part of the role of a judge, least of all of a constitutional court or even a civil judge, to defend their views. Once we declare a judgment, it becomes public property. It's the property of the nation. If there is the property of the nation. And,
I was only saying that your lordship's interim order of April 2019 asked the political parties to disclose the name of the donor. The information given by the political parties to the Election Commission, only a few of the political parties, the smaller regional political parties, some of them have disclosed.
He is not addressing your lordships, he is addressing somewhere else. Kindly hear him for some time. So that it comes, my lord, in the newspaper tomorrow, that Mr. Prashant Bhushan vehemently said this. That's the purpose.
Solicitor, unfortunately, public interest litigation has now become publicity interest litigation.
It is publicity interest litigation. It is, my lord, there are some hidden agendas. There is no doubt, my lord, and I am not, my lord, apologetic in saying.
I am astonished.
And Lord, that is the matter of greatest concern, because judgments given, my lord, for high constitutional principles then are used for purposes other than what they are delivered. Unfortunately,
Lordships, in your Lordship's majesty,
So what
would
I
not
was
know
pointing
what are the hidden
Let me
agendas behind it.
just dictate a short order. I
I
think,
just
we
point
are
out that
unnecessarily expanding upon the remit.
because the major political parties have not disclosed the donor.
Just give us 2 minutes to dictate the order.
Therefore, what all that I am requesting is that the disclosure of the details of the bonds should actually start from the beginning of the issue of the bonds, not just from the interim order, because this is leading to a situation.
1 second, we got the point. You filed an application on that. In our order,
They have filed an
just, Mr. Ansari, just 1 moment. Just do it in a very cool and calm atmosphere. It's a constitutional adjudication.
Yes,
Why should we, in our interim order, we said that the disclosure shall be made with effect from the date of the interim order,
Yes.
12th of April 2019.
Yes.
Right or wrong, we have taken a conscious decision that the cutoff will be the date of our interim order. And we also explain why we took that date. We said after that date, of course, the Constitutional Bench has an option to go all the way back from the date of the bond or from the date of the judgment, some place via media, some via media in between. We took 12th of April 2019 because it was our considered view of all of us five that once that interim order was pronounced, everybody was on notice, what we told Mr. Rodgi. Now we have maintained that if you want that to go back to 2018, that's in the nature of a review of the
So
judgment.
the only reason why I'm saying that,
modify that date.
no, the only reason, because your lordship asked the,
Of the judgment. We can't do it like this in a miscellaneous application.
no,
And
in the light of the disclosure which has come to light of the political parties, that's why I'm saying.
it was not a
If the
classical
political
disclosure,
parties
it was
had
a
disclosed the donor details, this would not be required.
draw the line somewhere. We had to hold the balance. We've held the balance ultimately.
As your
at
lordship
212.
pleases, but I just.
Can I just add one sentence? Lordship said all the details. Lordship may consider, my lord. I have pointed out that 6 details may be necessary, my lord. One is the serial number because they say 28,030 bonds have been issued. The second would be the date.
1 second. When you say serial number, you mean the alphanumeric,
Total
right?
number of bonds issued are 28,030. I'm not saying just. When a lordship said all details, not in my respectful submission, it will be.
Mr. Sarve,
No, my lord, lordship, just permit me a minute.
Sarve has fairly stated that he will
No, Lord.
all the details.
No, Lord.
Why?
yes.
No, my lord, if I can just show.
And dates are all already
Consider what your
disclosed.
lordship would say, my lord. I'm just pointing out what details can be there. First is serial number. Second is the date. The third would be alphanumerical number. Fourth column would be name of the donor. Fifth column would be the name of a political party. And sixth column would be the amount. My lord, this will cover all the details, not in my respectful submission.
My lord, this is now asking us to sit down and collate one
This
with
is
the
a
other.
submission made to the court. Just like Mr. Salve made a submission to the court. I'm making.
Yeah, we need.
Very well. I'm making a submission to the court. Mr. Salve asking us to do whatever. Look,
Please permit my lord the Chief Justice to dictate the order now at least.
Secondly, my lord, the lordship said, lordship has seen that IA, my lord. I filed that IA. For a preview, if a lordship have taken a conscious decision on that aspect of the matter, my lord, lordship may say, my lord, because the order said, my lord, the voters are entitled to know as a right of information. If a lordship have taken a conscious decision on that matter, my lord, it will be from 12th of April only because we said, my lord, it should be, my lord. Otherwise, logically, once the right to know, my lord, is inbuilt in the system, in right to know of the voter, then, very well, I'll leave it at that.
And there is a specific direction with effect from 12th April.
Then your lordship said, my lord, I have not pressed the
So
application.
Bhujan, there will be no end to it.
What is the IA number, Mr. Ansari? Just 1 second, Mr. Bhujan. IA number which you are not pressing is IA number?
Diary number 12580-2024, which is MA number, MA diary number.
So that you are not pressing.
Yes, my lord.
Just
Just
one,
say it. MA
by way
diary
of
number
information only.
580-2024. Mr. Vijay Hansaria, Learned Senior Counsel, appearing on behalf of the applicant, states after some submissions at the bar that the miscellaneous application is not pressed.
In view of
one
my lord,
thing.
whatever proceedings have gone to the court, in view of the proceedings before
Whatever in view of whatever.
Lord, if your lords, you can say that. my lord.
Oh,
Otherwise,
what? In view of what? We'll say, in view of the specific directions contained in paragraph 200, in paragraph 219, bracket B and C of the judgment of this court dated 15 February 2024.
Just one fact by way of information.
Enough of assistance by this public spirited person, my lord.
The details-
Your lordship doesn't need any further assistance.
The details of the number of bonds shown by the, in the data. which
He is
has been
gathering the
submitted.
details for a future PIL, my lord, so
The
that
number of bonds-
remains in he remains relevant.
Now, please permit the, why not the chief minister to declare the order?
Heard everybody, Mr.
I was just pointing out that there is a huge mismatch between the number of bonds purchased and the number of bonds encashed in the data submitted by the State Bank to the Election Commission. They are showing 18,871 bonds purchased, but showing 20,421 bonds redeemed. The total amount of bonds purchased is 12,155 crores, and the amount redeemed is 12,769 crores. That is 550 crores more than what were purchased. Now, the explanation for this could be because the data is from 12th April. At that time, the bond purchase was going on. On 12th April 2019, it was going on. What is possible is that some of these bonds were purchased prior to 12th April 2019, but redeemed after 12th April 2019, and that is why there is a mismatch. But I just wanted to point out there is a very large mismatch.
There is no, Malad, these figures are not authentic. I've given the authentic
18,000 versus
roughly
22,000 sponsored NGOs are, my lord, fudging the figures and bringing their own. My lord, your lordships are aware, there is a beautiful, my lord, quotation by Einstein that some people use statistics like a drunken man uses lamp posts more for support than for illumination.
I'm just showing the number. I'm saying that 18,000.
And this is what happens.
Right,
when
we'll now leave it at that. I will
Malad, those numbers are not right. Since, Malad, because all this is going to play out, the numbers are not right. The corrected numbers were not given in our application.
वो अलग order pass कर देंगे. इसमें MA में ऐसा लिख लीजिए. In subpara B and C of paragraph 221 of the judgment of this court dated 15th, the date of the interim order dated 12th April 2019. Stop. In other words, all details which have been directed to be furnished in the operative directions of this court are with reference to the interim order, are on the basis, don't say on the basis of, are with effect from the date of the interim order, namely 12th April 2019. Full stop. The relief which has been sought in the MA for predating the point of disclosure would amount to a substantive modification of the judgment and hence cannot be dealt with in a miscellaneous application. Full stop. The miscellaneous application is therefore not maintainable and is accordingly dismissed.
But I want one more relief to prevent another round of contempt proceedings. Would your lordship just for a minute have my affidavit in compliance for it?
What is it that you want clarification?
Yes. Malad, there was, when we gave your lordship, that's why I can see all this story has started. When we gave your lordship the original figure of 22,217 bonds, we had, by mistake, that was from 1st of April, not on 12th of April. If your lordship just sees para 4 and Malad, everything will be over because I know where this is going, where Mr. Bhushan is going. Please see para 4 of my compliance affidavit for 1 second.
Yes.
And please, I would invite your lordship to say, your lordships accept this. We have given the figures, Malad. There is no mismatch, there is nothing of the sort. The total, if your lordship sees the table.
We're not going to all that. I mean,
I have to convince my lord I have complied with the order. I'm just saying.
It's a compliance affidavit. It's a compliance affidavit of your chairman and managing director. We have accepted that.
Please say your lordships have accepted our compliance affidavit. That will put an end to all this.
By the judgment of this court dated 15 February 2024, this court directed, into inverted commas, this court directed, into inverted commas, the disclosure of information on contributions received by political parties under the Electoral Bond scheme to give logical and complete effect, into inverted commas, complete, to the ruling. Full stop. Thereafter, in paragraph 219, this court issued operative directions. These directions in subparagraph B and C are in two parts. Full stop. Subpara B requires SBI to submit Details of the electoral bonds purchased since the interim order dated 12th April 2019, into inverted commas, till date to the ECI, into inverted commas, complete. Such details, the court has indicated, into inverted commas, shall include the date of purchase of each electoral bond, the name of the purchaser of the bond, and the denomination of the electoral bond purchased, into inverted commas, complete. In the second part of the operative direction, in subpara C, SBI was required to submit, into inverted commas, the details of political parties which have received contributions through electoral bonds, into inverted commas, complete, since the interim order dated 12 April 2019, till date to ECI. SBI was required to disclose details of each, underline each electoral bond encashed by political parties, and to include inclusive of the date of encashment and the denomination of the electoral bond. Full stop. The above narration and the plain reading of paragraph 219 of the judgment dated 15 February 2024 indicates that SBI was required to submit all details, both in terms of the purchase and in terms of the receipt of contributions. Full stop. The expression, to invert commas, include in both subparagraphs B and C clearly demonstrate that the inclusive part was regarded as illustrative and not exhaustive of the nature of the disclosure which was to be made by SBI. Full stop. In other words, we now, there's no manner of doubt that SBI is required to make a complete disclosure of all details in its possession. Full stop. This, we clarify, will include would comprehend the alphanumeric number of, and the serial number, if any, of the bonds which were purchased and redeemed. Full stop. The application, this was on your application, I think you had moved this, no? The application was by the Oh yeah, we had this. Mr. Harishan Salve, Learned Senior Counsel, states that there is no reservation on the part of SBI in disclosing all details which are in its possession and custody. Full stop. In order to fully effectuate the order and to obviate any controversy in the future, we direct that the Chairman and Managing Director of SBI shall file an affidavit on or before 5 p.m. on Wednesday, date Daldo.
Could we have one more day on Thursday?
Stating, yes, certainly. 5 p.m. on Thursday, indicating that SBI has disclosed all details of the electoral bonds which were in its possession and custody, and that no details have been withheld from disclosure. Full stop.
To the Election Commission,
in terms of the directions contained in paragraph 221.
Your Lordship may indicate the date when it will be uploaded by the Election Commission.
The Election Commission shall upload the details forthwith on the communication by SBI.
My Lord, I had directed my Lord, the senior official of the bank to remain present. My Lord, the Deputy Managing Director and Chief General Manager are present here. The presence may be. They both are.
Fair.